The broadcast is now starting. All attendees are in listen-only mode.
All right, we should be live. I just give a second for people that might be signing in late. We are about to start this month's webinar, 3 things to know before filing a child support or spousal support modification. And quite honestly, it's going to be a lot more than just 3, but it's a catchy title, so they named it that way. For those that have not worked with me before, this is me. My name is Brad Micklin. I am the main attorney and managing member of the Micklin Law Group. I am licensed to practice law in New Jersey. The Micklin Law Group is a law firm concentrated in men's and fathers' rights with offices in Nutley, Montclair, and Southbrook, New Jersey. As I mentioned, we are focused on men's and fathers' rights. The next slide's a few awards that I've been fortunate to receive. I put them here not to impress my audience, but to impress upon them that I have been around for a significant amount of time. I have had a lot of experience, and I hope that my experience will help you, and that's the purpose of this webinar. Also, I've served as a national media legal analyst. Here's some of my appearances: Fox News, Inside Edition, Larry King, may he rest in peace. Again, not to impress, but to show that I have a wide range of experience. I've been called on many people and places for advice, and I hope that the content of this advice will help you also with your child support and alimony issues. So let's move right into it. When to file for modification. Your support and alimony order may need to be modified if your income changes so much that it's unreasonable to expect you to continue making the payments that you were originally agreed to or ordered to pay. Following are going to be some things you need to know before filing a request for modification. Now, a general rule of thumb is child support gets calculated or can be recalculated by using an estimate of 20 to 30% of your net pay, depending on how many children are involved. However, that's just a rough guideline. New Jersey, as with most states, have a child support guideline that is much more complicated than I'm setting out to be. I'm just giving you a rough idea so that you can base it. But the guideline itself will calculate support based on the combined incomes, the overnight parenting schedule, any kind of extra ordinary medical expenses, healthcare, and some other issues. So turning into the reasons when to file for modification. To file for modification, you're going to need to show that your income has changed significantly since the last support order was issued, which might be difficult if you just recently lost your job. Significant changes that may affect support include loss of employment, illness, or injury that prevent you from working, increases in your income, and the addition of another child to your household, among many other reasons. In your motion, you're going to have to show that the income from all available sources, which is not just your job, but if you have any support that you're receiving, if you have investment income, interest income, things like that, will also be counted. And you'll need to show that it's dropped at least by 15%, if not more, in the past 3 months. And then it's expected to drop by at least 15 in the future and remain for a long period of time, if not indefinitely. Also, gaining a higher paying position may be reasons to modify support if you're on the receiving end of the support. So if you're the recipient and your ex-partner or the parent you find has increased his or her income by the same 15-20%, that may also be reason for you to seek an upward modification of support. Changes in parenting time, whether they increase or decrease, can impact child support, as I indicated, is one of the criteria that are utilized in the child support guidelines. But it doesn't mean it's just one day has changed or another day has changed. It's usually if you have a significant overnight expended parenting time, like a big summer break, a month or two in summer, maybe a couple school vacations. And I say that because the child support guidelines do not stop child support if you have the child for an extended period of time, like a month or two in the summer. So it may be reasons to change support based on your parenting time, even if it's a temporary change, just for instance, like the summer example that I'm using. Additional reasons to modify support can be health issues of either the parent or the child. The health issues have to be something that impact your ability to work. When it's a child's health issues, it's something that usually would require extensive medical treatments and expenses. Changes in your family situation, such as a disability, a significant medical expense, or birth of another child. And any other significant changes in the expense of the family. Now let's take a look at some of the logistics of filing for a child support and alimony modification. Oh, I'm sorry, the last slide I think I covered. Additional children for the party to support. It's called an alternate dependent deduction. So if you have a child support or alimony obligation and you have another child in a different relationship, the law does support a modification of your child support by claiming what's called an alternate dependent deduction. I guess it could be considered basis to change your alimony order because it also would be a material and substantial change of circumstance. I hesitate just because I don't know if I've ever seen that in practice, either for a client or on the other end of an application, but I don't see why you couldn't use the change, the increase of your children as a reason to modify your support or your alimony. Next, logistics. So here we're going to discuss how to file, timelines for filing, and the necessary court appearance that you can expect when you do file for modification. Okay, so the modification can affect your visitation rights. It would be considered as a possible factor for modifying custody and parenting time arrangements. So it's important to know how to file modification of child support in New Jersey. Now, simply put, New Jersey courts follow the statute of NJSA 2A:17-56.39, which isn't so important for you to know or use, but I'll say it again in case you want to research it. It's NJSA 2A:17-56.39, which states that there must be a written agreement or court order for modification to take place. In addition, modifications of child support in New Jersey should be done so that it doesn't cause any harm to the other parent or the children involved. Modification of support, especially child support in New Jersey, is important because it can improve your life while trying to keep the best interests of your children in mind. Keeping in mind that there are some limitations on how modifications get filed and how much modifications you get, the material that's going to follow is intended to help give you some of the basis to move forward. Now, how to file. If you're considering to modify your child or alimony obligations, there's going to be certain documents you need to submit with your motion in order to prove that a change is warranted. We're going to outline those documents are, what those documents are, and provide some tips on putting together a strong case. Keep in mind, modifying child support can be a complex process, so follow these steps and information carefully. First, let's look at some steps to file it. So first, you got to file a motion or application with the court. Now, these documents must be filed in the original court that issued the judgment or the consent order if you did this by agreement. So if you were divorced, if you got child support through a divorce, you'll have what's considered called an FM docket number. That's family and matrimonial. That'll be the first two letters of your case number that must be included in the paperwork that you file. Non-dissolution is anything other than a married couple that have children or support court obligation. That will have an FD docket number, that's family And D actually stands for non-dissolution, even though that begins with an N. There's an FN docket number I won't go into, so because of that confusion, they call this FD as in family David. The documents have to be served on the other party. Now, the best and safest way to do that is to send them by certified mail, return receipt requested, and by regular mail. The reason is the court will say if you send the papers to the other party, certified mail, return receipt requested, and regular mail, and the certified mail is not acknowledged or signed, but the regular mail is not returned to you, the court will consider the other person received the papers. Now, there are other less formal options. They're usually best if there's an attorney on the other side, or if you have cooperation and you can trust the other party, but more so when there's an attorney on the other side, and that would be by regular mail and more commonly by email. But if you're going to send it by email, especially if it's on a non-attorney, have them confirm that they did in fact receive it, but still consider sending it by certified regular mail because the court rules are a bit archaic. They haven't been changed even with all the changes in court with the pandemic and electronic filing. So until those change, I still recommend that you do it by certified mail. So moving on, a couple of slides to move forward here. So if you're going to be modifying something, like I said, there's going to be certain documents that you need. So the first is a notice of motion. And these are all, or almost all, are forms that have to be copied in one way or another to be similar, if not identical, to the other forms that are used in court. I often recommend if you're not using an attorney that you go to either the New Jersey Judiciary website or there's like Rocket Lawyer and all those online websites that try to find a form for New Jersey motion. And again, either the FM docket number and FD docket number, because as we talk about soon, that they're actually going to be very different. Notice of motion has certain requirements. If you get the form, it's largely a fill in the blank, indicating that you're looking to modify your support obligations and how much you're looking to modify. Certification of mailing, which will indicate that you did send a copy, either as I indicated by certified regular mail or email, or however you did decide to mail it. Notice to litigants, again, it's a form. I won't go through the great details. If you're downloading a form online and it's clear that it's designated towards a New Jersey family court, it will likely have a notice to litigants. If not, just run a web search, New Jersey notice to litigants, and you should be able to find a copy. Then there's a certification from you, assuming you're the one seeking the modification. Now, in the certification, you obviously have to set forth the reasons why you need to modify your support obligations, as well as what led to the support obligations, if you can recall. Attaching to that, you should put several things that will help the court decide how it was set originally, whether it should be modified. And that would include the original order of support, something called a case information statement. I'm not going to go through that at length either. I do have a webinar specifically on how to fill out a case information statement on a YouTube page. You should check that out. You want to get the case information statement. If you filled one out at the time that your support was entered, usually that's in a divorce case, you want the original one. And then anything else that supports the current needs and lifestyle that you have, as well as the change of circumstances that you're experiencing. Proposed form of order, again, it's going to mirror the information you put in the notice of motion, but it's going to be a slightly different form. Again, either if you're not going to have an attorney, find an online form, make sure that it's specific to New Jersey. Although the courts will be a little flexible if you're representing yourself. If the form's accurate but not perfect or identical, they will still likely accept it, but don't take that risk if you don't need to. And then the letter brief, that's not something that you're likely to be able to find online. It's not always necessarily to modify support, but it's recommended. So if you can find a way to get a letter brief, which is just outlining what the law says for the reasons to support modification and including the facts of your case and showing why they mirror one another, lending to asking the court to modify your support. Now, next we'll talk a little bit about, and the filing fee in a post-divorce case is $50, at least as of 2022. So now we'll talk about a little bit of filing a modification in an FD case, which is not a divorce case. So first, again, let's talk a little bit about the documents that are necessary because they're slightly different. Actually, not slightly different, they're significantly different. And these can all be found online or through the courts directly because they created these forms so that there'd be uniform filing with people who generally in this court don't have, not generally, but often don't have lawyers. So they made standardized forms. So the application for modification, you see the form number on my slide, 11487. The order, which is what you're seeking again for them to enter. And your supporting documents, same with before. The main difference is you're not likely to have a case information statement. Instead, you'll have, what should be coming up in a second here is, confidential litigants information sheet. That again is a form that you fill in. Financial statement of summary support. Now, this is what I was about to say a moment ago, similar to your case information statement, in that it's presenting your financial information, but it's not identical in the form. So do not use a case information statement in an FD family David case. You need to use the financial statement of summary support, form 11223. You want to attach your income information. This will also go for matrimonial, the divorce filings, and for non-filing. You want to put your 3 most recent pay stubs if you are working, or your 3 last pay stubs, your most recent tax return, and your most recent W-2s or 1099s, along with any other information that supports your change of circumstances. And there's a $25 filing fee for an FD case. Next is timeline. If you're considering modifying your support, you want to know how long the process will take. Now, in most cases, it will take several months to get a modification finalized. Keep in mind that every judge in every county may have different process for scheduling their hearings. I mean, there's a uniform process in New Jersey where same judge gets the case back post-judgment. They're supposed to be on an alternating Friday hearing dates. But with COVID and the recent changes with electronic filing and the backlog that has been caused by it, some counties are implementing certain processes that others aren't. Certain judges are implementing certain processes that other judges aren't. So you need to know that it may vary from time to time. I would recommend speaking to an attorney in your county before you go into this process. That being said, let's take a look at the initial scheduling timeframes. So an FM matter, the family or the divorce matter, the notice of motion has to be served 24 days before the filing or before it's supposed to be heard, which the notice of motion form will ask you to pick that day. So it's an alternating Friday schedule, 24 days from the day the court gets it. Whether you pick the right or wrong date, the court will put the date on it when it receives it and send it back to you. So try to calculate right, but don't get hung up on that so much. So the notice of cross motion, if you're receiving an application to modify support, you have to file a cross motion within 15 days of the return date, not 15 days from your receipt of it. So again, find out what the court scheduled it for and calculate 15 days back. There's a court rule that talks about what days you do and don't count for calculation. It can be a little tricky, so you might want to read up on that or talk to a lawyer. And then if you're responding to a cross motion, if you filed the original application, then you have 8 days from there to file a response. Sorry. Okay, so in an FD matter, the non-moving party does not have to file a response, which means if you're filing modification, the other person doesn't need to file anything before the hearing date, but they can. The moving party, which in this case probably you, have to schedule 16 days you have to file and serve it 16 days before the hearing date, which again, the court's going to schedule. It's just so that you know how long these things are going to take. All right, so now let's talk about the different types of hearings that you may encounter in a modification process. First is oral argument. That's when you and the other party appear in court and you stand before the court and argue about what's in your papers. Basically, you're limited to what you put in your papers. I truthfully don't really understand the point of oral argument unless the judge has specific questions for you, but that's usually not the case. That's generally going to be required, and we'll talk about that in a second when we talk about a plenary hearing, but more often than not, the courts will have oral argument just to avoid errors on the record and appeals. They can decide the motion on the papers. I think that they should more often than they do. They will tell you usually that that's going to be the case. You can also call 3 or 4 days before the scheduled date to make sure that there is oral argument or whether your motion is on the papers. Some courts provide a tentative decision, which is a written decision a couple of days before the hearing telling you what they're going to decide, then giving you the opportunity to argue in court or not. I generally don't think it's helpful to argue in court after you've received a decision. It's unlikely you're going to change the court's decision. As an attorney, I will usually take the argument if I don't think the cost will outweigh the benefit, because it's good to keep a clean record. And sometimes you can clarify some errors that the court may be making in its decision. Otherwise, it's very hard to change a judge's tentative decision. Plenary hearings, that's a short but complete trial. Sometimes when modifying support, the court will require a plenary, and that is when the paperwork that you and the other person file conflict with one another and the court doesn't have enough information to make a final decision. They will usually schedule a discovery period, which will be the exchange of information, tax returns, credit card statements, bank statements, agreements, anything, depositions that would normally be required. I consider plenary like a mini divorce, actually. You will have examination or cross-examination at this plenary hearing. Again, the topic very complex. I won't go into, but I do have a webinar on my YouTube page about how to conduct both cross and direct examinations at trial. And then the judge will make a ruling, sometimes at the hearing, most often afterwards, and usually in writing, just because there's always a lot of information to process. Additional court appearances, case management conferences, that's a scheduling conference the court will hold every few months inside of most litigations, including a support modification. And it's really to find out what has been completed, what remains outstanding, and what needs to be done before we can have the actual plenary trial that concludes the application. You'll have mediation. Usually the court will schedule several forms of mediation. That is where you and the other person meet with an attorney or a judge or somebody that you hire in a confidential process with the hopes of making an agreement. If you come to an agreement, it's binding. If it's written and signed only. If you don't agree, then you just continue back to court. Again, I have several videos on mediation as well as arbitration, a slightly different type of process that would be helpful for you to review to understand this. Usually, not usually, a mediator will be a neutral third party. It can be really anybody that you two agree on. Commonly, it's a lawyer or a judge, as I mentioned. Sometimes it can be mental health experts if there's custody issues that are involved also in this. It can be a financial advisor, really anybody that the two of you agree to. So one, in conclusion to it, now if you're going to find yourself before a judge, whether it's an oral argument or in a trial, just remember a few key things. Always be respectful, speak clearly, and answer any of the questions that are asked of you. Judges get really frustrated when they ask a simple question and people are very defensive, or what I say, they're in their head trying to think of what it means and just not answering it. Judges aren't there to get you or hurt you. They're there to help generally. So they will appreciate when somebody is honest and respectful and just answers the questions that they want. So let's talk about the decision criteria. So when you go to court, the outcome of your case will depend, obviously, on what the judge decides. Judges have a lot of power in the courtroom, and they make a decision that will impact your life in a number of ways. So let's take a look at some of the factors that play into judicial decision making. So when child support is ordered and alimony is ordered or modified by a judge, it's typically based on your income and ability to pay. However, there are situations in which a judge may determine it's appropriate to modify support either by increasing or decreasing the amount. So there are going to be several factors to consider when making this determination, such as the main criteria is a substantial and material change of circumstances. Now, the problem here is that's not defined clearly in the law. It could be, like I said earlier, 15 or 20%, it could be 10%, it could be 50% decrease, but it's your burden of proof to establish that your circumstances have changed substantially. It's got to be permanent and not voluntary, meaning you can't leave your job and start pumping gas to modify your support. It also can't be that you've been out of work for a couple of weeks and you just want to modify your support. You have to be able to show that it's going to be several months since you've lost your job, that you've been unsuccessful finding another job, and that is likely to be long-term, if not permanent. Now, calculating child support have many criteria. I'm going to go through these as quickly as we can. Needs of the child, standard of living and economic circumstances, all of your income and assets, as I mentioned before, your earning ability, the needs and capacity of the children, including education, health and age of the children and parents, income, assets available, responsibility for support of the parents for court order of other dependents, debts and liabilities, and then any other factors the court deemed relevant, which again is something that has no definition, but something to keep in mind if you have an unusual case. Next, we should be turning into alimony. So alimony is also called spousal support, the payment from one spouse to another, either on a regular or non-regular basis. Judges have discretion in determining the amount of alimony to award each party, and the factors that can be considered when determining the amount and duration of alimony include the following, and I'm going to go through these also quickly. I'd recommend either you go back and read the webinar or you go online and just type alimony factors, but the needs and ability of the parties to pay, length of the marriage, age of the parties, standard of living during your marriage, earning capacities and skill levels, employability, absence from the job market. That's usually towards the recipient. I guess it would be really either party, but most often it's the recipient. Parental responsibilities for the children. There are a couple others. Time and expense necessary for acquisition of education. History of financial, non-financial contributions to the marriage. Non-financial could be like running, or not running, like raising children, for instance, the most common. Equitable distribution of property and profits. Income available through investments and other assets. Tax treatment and consequences of the alimony, which I won't go into also, that's a significant point, but keep a note that federal and state tax consequences of alimony are different, and a lot of lawyers miss that stage. Nature and amount, length of temporary support, penitentiary light support, and any other factors the court deems relevant. Once again, we see that common in statutes. Now, you may be aware that alimony has been updated. The alimony statute was updated in 2014, which is a step forward for those that wanted more fairness when it comes to determining how much money they would receive or pay once the marriage ends, or one spouse earns significantly less than the other over time. Because without the change in the statute, many people felt like there was no legal standard at all. So a law was passed which reformed the alimony statute so that lawyers now just can't use simple calculations like they were doing in the past. but the guidelines are much more rigid. So in 2014, they tried to codify how attorneys were determining alimony on what they thought was fair, but making more specific determinations to avoid, I guess it'd be like an informal practice that judges and lawyers were using. So one major change was when you're a non-self-employed party, with the drew a distinction between self-employed and not self-employed. Reasons for the loss of income will be a criteria. Your efforts to get employment afterwards at a comparable level are significant. The income circumstances and efforts to obtain employment since you've lost the job, and the impact of your health and other abilities to obtain employment. Again, with a non-self-employed party, severance or compensation you received when you lost your job, any changes in your financial circumstances, actually on both sides, both you and the recipient since the order was entered. The reasons for the change in these financial circumstances, again, on both sides of this table, and whether temporary remedies should be involved. So they can modify support temporarily, and they can also modify enforcement, but not change the numbers. So courts have a lot of remedies available if they don't believe it's permanent, but they want to give some kind of temporary relief. And again, any other factors the court deems relevant. Now, determining alimony with self-employed parties with involuntary reduction in income, which is one of the newer, more in-depth areas of the modifications of the alimony statute, must include analysis of your perks or your benefits, cell phone, car payments, entertainment, credit cards, reimbursements, things like that. Because, and basically, in a nutshell, they realize that many self-employed individuals receive income in forms that don't show up on a tax return, economic and non-economic. So you're going to have to set forth what kind of receipts, vacation time, things like that, unreimbursed healthcare, insurance payments. Oh, I'm sorry. No, that was it. Okay, let's just go back to slow down for a second. So your application for relief has to ensure your economic and non-economic perks. Very important that as a self-employed individual that you either submit or be prepared to submit not only your tax returns, but your business and personal bank statements, QuickBook ledgers that you have, anything that shows the cash flow. Because the general belief is going to be, if you're self-employed, you are receiving a substantial amount, not substantial, but you are receiving perks in one or many forms. Thank you. That does conclude our information. Here is the website that you can go to for additional videos, blog posts, and resources. I also have a plethora of videos on my YouTube page, which is just Brad Micklin, M-I-C-K-L-I-N. On YouTube, I think you just search by my name. We have a Facebook social media page, again, Micklin Law Group, and then you can email me at brad@micklinlawgroup.com, which once again is MICKLINLAWGRUP.com. And the phone number, if you wanted to schedule a meeting with me, is 973-562-0100. Thanks. I hope this information helps, and I hope everybody's staying safe.